Good evening, everyone, and welcome to this webinar on startup strategies for protecting brands and innovations, which is organized by LawSikho. Today, we are honored to have with us a distinguished expert in the field of intellectual property, Mr. Karthik Putaya, CEO of Inventory, an intellectual property consulting firm renowned for its strategic counsel and comprehensive solutions in intellectual property management. Under his leadership, Inventory has become a trusted partner for startups and businesses around the globe, offering invaluable insights and guidance in protecting their innovative ideas. In addition to the above, Mr. Karthik is a passionate educator and a leader. He has actively engaged in sharing his knowledge through workshops, seminars, and educational initiatives. It is with my immense pleasure that we welcome you here, Mr. Karthik, as a speaker, and I hope that our listeners here today will be benefited with this webinar. Good evening.
Hey, thanks a lot for that introduction, Manita, and excited to be here.
Yes, equally excited here, sir.
Yeah.
So, let's begin with getting to know you a little bit better. If you can just share a brief background about you and what led you to become the CEO of Inventory, like why did you start it, and how did it all happen?
Sure, yeah. So this is, me getting into intellectual property consulting. It's pretty much, I would say, not by design. It's more of an accident in terms of how it turned out. So from education, I'm a mechanical engineer.
Okay.
So soon after my engineering, like most people in Bangalore would look for jobs within the IT sector. And I was, while I was inclined towards that, at the same time I was also exploring options outside of IT, which could in a field that could be exciting. And as luck would kind of have it, I came across this particular field through a company called evalueserve, who kind of reached out to me and wanted to explore if I could join their team. That's how I kind of got exposed to this particular field at that point in time, particularly in patents. And once I started my career in patents, which seemed like a very exciting field to be in, I continued to work with that particular company, and thereafter moved on to another company in Bangalore. So worked with other companies, firms for about 5 years. After which I started inventory in back in 2010.
Okay.
So yeah, so when we kind of started inventory in 2010, it was primarily a patent consulting firm, and eventually we kind of evolved into a full-fledged end-to-end IP consulting firm. So that's how the journey has been so far. Yeah.
Okay, so first of all, let me say that the name of your organization, Inventory, is really innovative. It's
Thank
really
you.
innovative. Yeah.
Yeah.
So,
Yeah.
like when you started this organization, what was the trajectory like? Since, starting, see, IP is not a field which is not tapped yet. And even though in 2010, when you started, maybe at that
Right.
point it was a new field. So, what was the
True.
trajectory when you once started in the beginning and then till now?
Yeah, so when we started back in 2010, most of the work that we used to do was essentially what people refer to as patent outsourcing work.
Hmm.
So back in the days, there were a lot of U.S. companies and U.S. law firms who had, let's say, some tasks with respect to patents, so on and so forth, which they were kind of outsourcing to India, right? So the majority of the work that we were doing when we kind of started was essentially providing all of these services to either US companies or US law firms.
Hmm.
And then eventually we started also getting into the Indian ecosystem, wherein you essentially had even startups kind of started thinking about IP specifically in patents. Started thinking about it, so we started giving our services to Indian startups. Then as we kind of moved up the ladder, there were a lot of large companies that we worked with. So even these large companies, primarily these companies happen to be, companies who are basically from outside India, but they do have R&D centers in India. Like, a lot of these MNC
Hmm.
companies that
Hmm.
are there in India, which have, pretty large R&D teams, right? So we kind of started engaging with these large companies and started providing our services to these large companies, apart from, continuously providing our services to startups. Now, I mean, just to give you an insight in terms of what the kind of work that we are doing. So while we have been working with with startups in India, we have been working with large companies in India. At the same time, a huge chunk of the work that we are doing is essentially for companies who are outside of India but want to protect their IP within India.
Hmm.
Just to give you an insight, roughly about 75 to 80% of the patents that are filed in India are from companies outside of India, right? So the
Right.
Indian companies essentially just make up to about 20% of patent filings. But when we talk
Hmm.
about trademarks, yes, there is a huge chunk of Indian companies that apply for trademarks. So
Right.
we have in our clientele a lot of companies outside of India also, who are essentially focused of protecting their IP within India. So
Hmm.
so in terms of the client spread, that is a wide range of clients. At the same time, the kind of services each one would require is also kind of, and the handholding which each one would require is also kind of different. For example, a startup would require a lot of handholding in terms of, what needs to be done, how it needs to be done, how do we do it economically, so on and so forth. Whereas the objective statements for a large company is much different, right? So we kind of uh, cater to the whole spectrum and then see different sides of things, so on and so forth. Yeah,
Hmm. So that was an exciting journey, I guess, that you went through. Like it
yeah,
started from just an outsourcing company, from there, and you're here right now. I was
yeah,
reading
yeah,
about your company, saw that it has a presence, like it is catering clients from around 43 countries. So that's a huge
yeah, yeah,
uh,
true. Yeah,
thing.
yeah,
So, so just to set a stage for our listeners, since some
sure.
of them might be startup owners and not advocates, let's first get into what IP is. And can you just like, go ahead and explain what IP is in simple terms, and what is the importance in today's world? Like why it
Right.
is important to protect it. Hmm.
Right. So for those who are very new to this world of intellectual property, yes. So probably it's kind of important to kind of understand what intellectual property actually means, right? Now, to just give an example, like the phrase mentions, intellectual property is a property that is created by the human intellect.
Hmm.
Many a times when we talk about property, we normally tend to associate it with tangible property, right? So,
Right.
for example, if I were to take the example of, let's say, a car. Uh, so the car, everybody understands that a car is a tangible property, right? While at the same time, there could be certain technology that is built into the engine, right? So which makes the car actually function in a certain way or perform in a certain way. So if somebody were to steal, let's say, the engine of the car, one would probably say that, okay, the property got stolen. So we are essentially saying that, okay, some form of tangible property got stolen, right? But
Hmm.
imagine a scenario wherein the engine is not stolen. Instead, another company copies that whole technology, right? So you know that something physical has not been stolen, but it is the creation of the intellect, which is the technology behind it, that got stolen in this particular case. Right. So that is the
Right.
intellectual property, that is the intangible property associated with this particular tangible property, right? So anything intangible in nature which has certain value to it is called intellectual property. And then there are again, various types of intellectual property. And in terms of the importance, see, it's extremely important. Intellectual property is an extremely important part of any business, any venture. And depending on the kind of venture or the kind of business that you are in, different types of intellectual property might be important. For example,
Hmm.
if you're a technology company, the kind of intellectual property that is important to you could be what is called as patents.
Right.
Let's say you are a company that essentially, your core ideology or the core aspect of your business is your brand, right? In which case, it is the brand that is important. The brand again is your intellectual property. For example,
Hmm.
if the consider a shoe which has the Nike logo on it, right? So the kind of price it can command as compared to the same shoe without the Nike logo, you can think of it, right? So that is the brand
Hmm.
presence. So that is the trademark
Hmm.
of the Nike company. So somebody like that, wherein the brand is extremely important, in which case the intellectual property associated with the brand, which is called as a trademark, is what is kind of important. So depending on the nature of your business, there are multiple types of intellectual property. Maybe we can talk about it in future, but yes, it plays an extremely vital role in any business, so to say.
Okay, so basically, how can a business, uh, like, why should someone protect it? Why should a business protect it? And we'll go to startups specifically, but why should a business, any business protect? You said that they are crucial, and we all understood that, but why should we, like, a business
Right,
will protect them?
right.
Hmm.
Now let's imagine a scenario wherein, as a company, let's say, uh, we are into, let's say, manufacturing of automobile, right? Now let's within the automobile, there are multiple parts of an automobile, and we keep innovating in different aspects of what creates an automobile. So which means to say that we are investing in R&D so that we
Hmm.
can bring about an improvement in that particular technology, or we can have a certain feature that is essentially absent in the current world, right? Why would we want to come up with that particular feature? Because if we were to kind of add that feature, the possibility of we being able to compete in the market could be much better. So for example,
Hmm.
let's say, I have come up with a technology wherein I am able to open the door of a car by pressing a button in my phone using an app. When
Hmm.
it exists, let's assume that that were to be a feature that we have worked on and then we have come up with, right? Which means
Hmm.
to say that there is a lot of money that has been spent on the R&D. Now we have come up with that particular feature. Now we want to make sure that since we are the first to come up with this particular feature, we want to ensure that nobody else should have this particular feature in the market, right? Now, to be able to stop others from coming up with the same feature, right,
Hmm.
there needs to be some form of protection. In which case,
Hmm.
if I were to apply for a patent and get a patent granted on that particular technology, then I can actually prevent everybody else from having that feature in their product. So, which means
Right.
to say that now I have a competitive edge in the market, which is a
Hmm.
monopolistic kind of a protection that I have over that piece of technology, using which I can sell my product better or I can price my product higher, right? So
Hmm.
without patent protection, the moment you get a feature into that particular market out in the open, within no time, let's say about 6 months, you have your competitors also doing the same thing, right? So that
Hmm.
is why protecting, let's say, your technology becomes extremely important using patents. So similarly, so let's take the example of trademarks. So let's say, Nike as such did not have any form of protection on their logo, which means to say that anybody, can just put that Nike mark onto their products and start selling it. In which case, it becomes extremely difficult. Their trademark gets diluted and they start losing market share. When it comes to
Right.
trademarks, of course, the kind of protection is slightly different, but the whole crux, I mean, registration of trademark as such is not mandatory, so to say, to be able to protect that particular brand name. But at the same time, if you have it protected as a registered trademark, than actually enforcing it and stopping somebody else from replicating your logo on their products would become much more easier, right? So these
Hmm.
are how it kind of ends up playing in the real world in business.
All right. Okay. So, in your example, you have already dealt with trademarks and patents, and you've also explained them. So let's explain copyrights and trade secrets as well in a very brief, just for our
Sure.
audience.
Right. So, when we talk about intellectual property, there is a whole gamut of, different types of intellectual property. We spoke about trademarks, which is essentially to protect, let's say, brand names, logos, so on and so forth. Then we spoke about patents, which is essentially to do with protecting anything to do with technology. Then we
Hmm.
have what is called as copyrights, which protects a whole gamut of things, including, let's say, literary work. So, which means to say that it could be, let's say, music, it could be a poem, it could be, let's say, a painting, it could be, let's say, a whole book or a novel, it could be, let's say, a certain. Uh, or it could even be software code which can be protected as copyright, right?
Hmm.
So again, just like trademarks, when it comes to copyright, again, which protects this whole gamut of things, registration of a copyright as such is not really crucial, it's not even required. But what happens is that, let's say somebody starts copying, or somebody has copied your literary work, or copied your source code, or copied, let's say, some music or something else. Registration of a copyright plays an important role in kind of establishing a date, associating a date to that particular work of yours, right? So that is where copyright registration kind of comes into picture. And typically copyright registration is done by, I would say, businesses wherein that literary work or the copyrightable work is the crux of the business, right? So,
Hmm.
for example, let's say I'm an author, I would essentially go ahead and copyright my book, right?
Hmm.
As compared to, let's say, I'm a technology company and I'm, publishing a lot of articles on a daily basis. Would I go ahead and, register a copyright? Probably not, right? Because I'm generating this content pretty much on a daily basis, and as such, content itself is not really the core to the business. So, in which case, I would probably not go that extra mile and go ahead and, apply for registration, so on and so forth. Anyway, I'm publishing it on my blog. There is some way of, putting a date to it, or some way of proving that this was the date on which it was published, so on and so forth. So I may not really go in for copyright registration. So one will have to be kind of aware as to, in what scenarios, in what business circumstances I would go for copyright registration, in what other circumstances I would not go for registration. So irrespective of whether it is registered or not registered, you can protect it, unlike patents where registration is kind of mandatory. Now, moving on to another thing, is what is called as designs. In India, we call it as industrial design registration. In, let's say, US, they call it as a design patent. Now, when I was previously speaking about patents, essentially I was saying that, okay, if you have some improvement in technology, you can go ahead and protect it, that particular technology as a patent. Now, let's consider a scenario wherein the product, the key one of the key aspects of the product is the aesthetics of the product itself. So let me just consider this particular mouse, right? It kind of looks a particular way, it has a certain shape, so on and so forth, right? So the shape itself is kind of appealing. There are many products which are sold, and one of the USPs of, selling that product is how that product looks. So, which means to
Hmm.
say that for a person, when they are making a buying decision, the looks of the product or the aesthetics of a product plays a very, very important role, right? So when a business is in a field wherein the aesthetics of the product play a very crucial role in the eventual selling cycle, You can protect the look and feel of that particular product in the form of what is called as a design registration. So when it comes to designs, again, registration is mandatory. So if you release a product without design registration, somebody could pretty much knock off that particular product, have another product which looks pretty much the same, and very, very difficult for you to kind of stop that other person from copying that aesthetics of that particular product. So if a business is in if the business is such that their products aesthetics is extremely important, then a design registration is highly recommended. Now moving on to the last thing, which is trade secrets. See, unlike like the name suggests, it's a secret, which means to say that unlike other forms of all the IP that we just discussed, wherein actually you have to disclose what you are trying to protect, but
Hmm.
in a trade secret, there is nothing to disclose. It is a secret. So, which means to say that as long as you protect certain information, you are taking certain steps to protect that information as a secret, it is a trade secret. So the basic principle behind that is that this information is essentially not available in public domain. So, which means to say
Hmm.
that this information that we consider it to be a trade secret is proprietary information, which means to say that we have come up with that particular information. Now, this information, which is kept as a secret and which we are considering it to be a trade secret, that information could be from different realms in business. For example, that information could be related to technology, it could be related to business, it could be related to a certain agreement, so on and so forth. It could be related to my sales strategies, what kind of sales strategies that I use. It could be related to the list of vendors that I have within my business and the price that I give to different types of vendors. How I
Hmm.
price my, sorry, more service or product, so on and so forth. So, any kind of information that is kind of proprietary in nature, that has some business significance, and you have taken certain steps to keep it as a secret, can be considered as a trade secret. And as long as you kind of keep it as a secret, it is kind of treated as a trade secret. Yeah. So that's how it works.
Okay. So now let's dive into some like a little bit of procedural part and just to make
Sure.
everyone understand how things are done. So let's first discuss about trademarks, like basically how a trademark protection works and what all are the benefits if someone gets it registered, and with and and after you answer to these two questions, I would like if you go specifically about startups. If you talk specifically about startups, how can startups leverage their trademarks?
Right. Now, I will talk about the process of trademarks. Now, even before I get to the process of trademarks, I would now essentially one of the ideas is how do you select a trademark,
Hmm.
right? So when we speak about trademarks, essentially, selection of a name or a logo or whatever it might be becomes a very crucial thing for it to be eventually be something that is defendable, right? So a trademark should be such that it should not define the kind of business that you are doing. So, for example,
Right.
let's say I am selling shoes and
Hmm.
I call my brand name is shoes itself, right? So
Right.
I am selling shoe and my brand name is shoe. So something a brand name like that, whether one almost impossible to get it registered because it essentially just defines your business, so it's impossible to kind of register. So even let's say you don't even register and you start using it, can you eventually defend it, stop others from using that particular brand name? Extremely difficult, right? So the brand name that you kind of pick should not directly define the product that you are selling or the services that you are offering, right? So for example, if I can keep a brand name shoes, and let's say I am selling water bottles, and to
Hmm.
and for that water bottle my brand name is shoe, so that is still all right. So although it's a dictionary name, when somebody hears the brand name shoe, they cannot simply relate that, okay, under this brand name it is going to be a water bottle that is being sold, right?
Hmm.
So the brand name is no way connected to the actual product, right? So that's an all right kind of thing. So what's a pure no is, a brand name that essentially just, describes the service that you're providing or the product that you're selling. That's one. Now, the second thing that you need to be very sure is that the brand name that you select should be such that there should not be identical or very confusingly similar brand names in the same field of business. Now, to give you an example, so let's say I run a company called Inventory. We are into the field of intellectual property consulting. Now, if somebody else were to start another company by the name of Inventory or something very similar in the same field, I can go ahead and stop them. On the other hand, let's suppose somebody now starts a shoe company and calls and uses the brand name Inventory to sell shoes. I cannot really go ahead and stop them because it is no way connected to your business. So the advice here is that when you are selecting a certain brand name, go ahead and there is the Indian Trademark Registry, which is like an online database, or you can engage with somebody to say that, okay, well, this is the services that I'm going to be selling or the product I'm going to be selling, and this is a brand name. Can you just go ahead and do a quick search in the Trademark Registry and find out if there is something identical or a confusingly similar brand name within the same field of business, right? Or a very similar field of business. But doing that due diligence would go a long way. I would highly recommend that even before you think of whether you register it or not, but the moment you say that, okay, I'm going to be using a certain brand name, doing this due diligence is extremely important, because you don't want to be in a position wherein you have not done any due diligence. You have spent quite a bit on establishing that particular brand name, and then you later on find out that, okay, there is a similar brand name used by somebody else in a similar field of business, and then that person is going to come after and then stop you from using that particular brand name. So that's something that's extremely important. Now, let's say you want to go ahead and register this particular trademark. Now, when we talk about registration is a fairly simple process. A bunch of documentation, and you essentially say that you have to select what is called as a classification. So all the different goods and services are classified into, there are like broad 45 classifications. These are like international classifications, a set of 45 classifications. So depending on the service or the product that you intend to sell under that particular brand name, so you would select which class this particular product falls under, and then you would select that particular class, and then go ahead and do all the documentation, and then go ahead and file this trademark application within a certain class. Now, there can be scenarios wherein your products could fall under multiple classes. So, for example, let's take the example of Tata. Now, Tata as such is into multiple fields of services, multiple goods, so on and so forth. So the brand name Tata will have to be protected under multiple classes. So in which case one would go ahead and file trademark app. So there is an option to go ahead and file a trademark application covering all the classes, but that's not a good idea to do it for multiple reasons. Essentially, because during registration, if it gets stuck in one of the classes, there are issues. Then the
Yes.
whole application is stuck for all the classes. So
Hmm.
and the cost involved in terms of government fees and everything is actually a multiple of classes. So if one class, if it is 4,500, whether you use the same application for different classes, then it is going to be a multiple of let's say 3 classes into 4,500. And if you do it in separate application, it is still the same, right? So it's ideal that there could be a situation wherein just like the data example, your business could fall into multiple classes, and ideally you would file different applications for each of those different classes and group all your services of one class into one application, and so on and so forth. So you go ahead and file the trademark application. So once you file the trademark application, it goes into the trademark registry. So there are 5 trademark registries. So it goes into a trademark registry depending on where you are located, so on and so forth. Now the trademark registry will go ahead and examine your trademark application, and when they examine it, as I mentioned earlier, in terms of selecting the trademark, the same kind of scrutiny is also done by the trademark registry. The first scrutiny is to see whether your trademark is such that it kind of essentially describes your goods and services and a bunch of other things, essentially to say that it's kind of descriptive in nature, and it is a word that is so generic in that particular field, right? So they would scrutinize your trademark based on that. That's one. And let's say it passes that particular scrutiny, then the next scrutiny would be to kind of check whether there are other trademarks in the same class which is identical or kind of deceptively or confusingly similar to the trademark that I am trying to register. So let's say they don't find anything else. It seems to be fine. Then they go ahead and say that, okay, we are ready to register your trademark. Now, the moment they say that, now it accepted for registration kind of a thing. So from that date onwards, it remains in that particular state for 4 months, right? So this 4 month period is given so that if somebody else has an objection to the registration of this particular trademark, they can come and object to it. But let's say in those 4 months nobody objects, then after those 4 months it goes ahead and gets registered. So this is like the fastest way where there was no roadblocks, nothing happened. You filed a trademark, they accepted, saying that okay, we are good to register, and then eventual registration. So we are looking at something like 8 months to have a eventual registration. Although registration takes time, the soon after you can go ahead and start using your trademark. You can file for trademark registration at the beginning itself, even when they have not even started using it, or you can apply for trademark registration at any point in time, even after you have started using it. But the registration time, like I said, would be roughly about 8 months in a scenario where there is no problems that encountered. But typically, you can say that about 50 to 60% of the applications, or even more, slightly more. I would say roughly about 75% of the applications, the trademark registry will certainly come back and say that okay, one, they could come back and say that well, your trademark looks like it's very descriptive in nature, describing your products and services, so nothing very generic, so forth. Or in addition to that, or without that, they might come back and say that look, we found all of these different trademarks in the same class, and we feel that it's very similar to these other trademarks. So they come back with these kind of examination reports, object into the grant registration. In which case, we'll have to respond to it. We'll have to kind of rebut all of those objections and try to convince the registry, saying that okay, well, you have come up with all these objections, but they are all misfounded for such and such reasons, and we need to try and convince them. So this is all written communication that is happening between the trademark office and, let's say, a consultant like us, and then eventually they get convinced and register it. Or if they're not convinced, then it's a one-on-one discussion like this, or a video conference, wherein again you try to kind of convince the trademark registry about something like this, and then eventually a trademark is registered, or it is eventually registration is not granted for whatever reason. So if at all you encounter objections like this, then we are looking at a timeline, exceeding a year for eventual registration, right? So to judge, whether we are going to encounter things like this, so on and so forth, it's better to do the due diligence even before you apply for a trademark registration, right? Um, so in terms of the expenses involved, see the government fees, as I mentioned, depend if you are applying it in one class. The government fee for a small startup, or a micro entity, small entity, MSME kind of a company, it's just about 4,500 per class. When you're applying for a trademark, you are spending roughly between a decent budget to have is roughly between 5 to 10,000 rupees to apply for a trademark. And if there are no objections, then it just sails through. But if like I said, there are these objections, and then somebody has to respond, so on and so forth. So you need to kind of budget somewhere between 10 to 15,000 rupees in these kind of scenarios. And so that's roughly the budget that you are kind of looking at when it comes to trademark registration. And this is the process and the rough timelines around it.
Thank you so much, sir, for that comprehensive understanding of, the
Sure.
trademark process. That will really bring enlightenment to a lot of people
Yeah.
who are not aware of it. And, and thank you for answering that question as well, which I didn't ask, that what how should someone select a mark? Because yes,
Yeah.
that is something that as advocates we encounter a lot, that people choosing
Right.
marks that are so generic, and then they're like that we are already working for like 2 years on this mark, we cannot change it now, which is again a
True.
genuine thing, but it's not registrable. We cannot register that mark.
Yeah, it's not
It would be a
registrable.
waste of.
And yeah, like I
Hmm.
mentioned, even if it is not registered and marks, even if they are not registered, you can actually go ahead and defend it. But if it is a very
Hmm.
generic name, uh, defensibility becomes a huge issue, right? So they might end
Difficult.
up
Would become super
continuing
difficult.
it, but you always are running the risk of somebody else also copying that particular mark, and then the whole brand is diluted because there are a bunch of people using the same name and all of that.
Right, right. So, discussing like on the topic of trademark, what are the international ramifications for a trademark? Like, since it's not like that a brand is working in just one country. So, how does that work?
Right. So when it comes to international so like I mentioned, one is registration is as such is not mandatory. So let's say we are working in India and we are using a certain brand name with registration, without registration, there is an amount of certain rights using which you can defend and stop others from copying it. So which means to say that let's say I'm using this particular brand name, let's say in US, since I am actually using this brand name in US, it should ideally be recognized as a trademark in US. And if somebody were to copy that particular brand name in US, just like how in India without registration I can stop it, even in the US I can do the same thing, even without registration. The
Hmm.
essential point here is that registration essentially makes it easier for you to defend. And considering that trademark registration may not be that as expensive, relatively not that expensive, and the importance of brand name for most businesses, registration is highly advisable. It just makes your job easy at some point in time. Now, when it comes to international registration, let's say you want to actually go ahead and register it. Now, there are different approaches to it. One is just like how you would file a standalone application in India, you can go ahead and file a standalone application in, let's say, US. You could do that, right? So, in each and every country where you want your trademark to be registered, you can go ahead and file trademark applications in each and every country. So that's one approach. Now the other approach is what is called as a Madrid application. So there is something called as Madrid protocol. So there are a bunch of countries which are part of this Madrid protocol. Even India is part of that Madrid protocol. So essentially, in this Madrid application, what happens is that it's a single application that we file, and when we are filing this application, we select saying that, okay, I want to select US, I want to select China, I want to select, XYZ countries, right? So I would select all of these countries and with this Madrid application. So what happens is that when I file this Madrid application, my application is sent to all these different countries. Now, the advantage of doing something like this is that if I were to go ahead and file, individual applications in each of these countries, I would engage with a trademark attorney or a trademark consultant in each of these countries. So, to file the application itself, let's say I have a bunch of 10 countries, I will spend even for filing on the attorney fees, right?
Hmm.
So using this matted application, I file a single application, and that application is now passed on to all these five different countries. So which means to say that at the time of filing, I don't spend on these attorney fees. So the filing is done. Now, once it is filed, each of these countries will do the scrutiny just like how the Indian Patent Office does. Each of these individual countries will do a scrutiny. If it is registrable, they go ahead and register it. But if it is not registrable and if they have objections, they will raise those objections. At which point, you will then start engaging with individual attorneys. So the
Okay.
engagement with individual countries would be at a much later stage, if at all it were to be required. So from that point of view, you would have filed the attorney fee in terms of filing, which you would have otherwise done if you had gone to individual countries. So whether you go for but the Madrid application itself can be slightly more expensive. So you will kind of take a decision as to whether I will file a Madrid application and then select multiple countries, or whether I would, go to individual country without this particular route, would depend on how many countries, in how many countries I want registration, and in
Right.
which are those countries where I want registration. So depending on this math, I would decide whether I would want to go this Madrid route, or I will go the individual route in all of these countries. Yeah.
All right. Okay. So, shifting our discussion to patents, what's the role of patents in protecting innovations, and why should inventors and companies and startups consider patenting their inventions, basically?
Right. So, like I mentioned, when we talk about patents, companies who work on technology, be it any field of science and technology, and that is one of the core aspects of the company, right? They would consider patents as one of the forms of intellectual property, which is vital for their business survival and for their business to thrive. Now, when it comes to patents, so there are, unlike other forms of intellectual property, getting a patent protection is a fairly complex process, and the benchmark and the standards that govern what can be patented is also quite high as compared to other forms of intellectual property. So essentially,
Mm,
for something to be protected as a patent, the technology should be considered as an invention, right? So, what is an invention? Invention can be any product or any process which relates to a technology or a field of science that is can be considered to be new, which means to say that it is something that is done for the first time in the world. So I cannot say that, well, something is being done in US, this technology is already known in US, but nobody is using this in India. So sometimes we get this question now, since nobody is being doing this in India, can I protect now? Can I bring that technology in India and get a patent in India? So that's not possible.
mm,
So irrespective of in which country you might be applying for a patent, for something to be considered as patent worthy, it has to be an invention. An invention is something new that new considering whatever is there across the world in public domain, right? So one is the newness. So the technology, there should be some aspect that can be considered as new. And the second important aspect, and I would say the benchmark that is kind of fairly difficult to, or relatively difficult to achieve, is what is called as obviousness. So many a times something could be new, but that thing might be very very obvious considering what is already known, right? So for example, let's say, we know that a pen has a cap, right? Now let's take an example of, let's say, a stylus that people were using, which you probably use to operate your, let's say, phone or your iPad, so on and so forth, right? If at all there were to be a such stylus. Now a stylus does not have a cap. Now let's say you say that, okay, I've come up with a stylus which has a cap, right? Now if I were to think about this, styluses never had a cap, so which means to say that it is new. But is that obvious or not is the next question. Well, it might be considered as you obvious because we had pens with had caps. Now you are just introducing the same cap on a stylus, so which could be considered as as obvious. So these are the different requirements for somebody to get a patent granted, right? So these are the core requirements. It has to be something related to the field of science and technology. It has to be new considering what is there across the world. It should not be obvious considering whatever is there in public domain across the world. If these things were to be satisfied, then there are chances that you would get a patent granted, and then there is the whole patenting process and all of that. But why would somebody go ahead and apply for a patent, like we were discussing earlier, right? So you would have invested so much on your on improving, or you would have, even if you have not invested, using your intellect, came up with something very very brilliant, and there should be some way of protecting it, because if you were to protect it, you would have monopolistic right over that particular aspect of your technology, and if you get monopolistic right, there is a lot of business advantage, right? That is why you would want to go ahead and apply for a patent and protect your invention or your innovation using a patent. And unlike other forms, for example, I mentioned about trademark, wherein you could apply for a trademark registration at any point in time, but patent doesn't work that way. You have to apply for a patent before making your technology public. So it has to be done before that. In some
mm,
jurisdictions, there is some amount of grace period. For example, if you were to look at US, you might have the grace period of about 12 months even after you have made your technology public. But to be on the safer side, in most other jurisdictions, you would want to apply for a patent before you make your technology public.
mm. All right. So, understanding what a patent is and why it is important, let's dive into the process. Like, as you explained the process for trademark, I would really
Sure.
appreciate if you explain the process of a patent application as well.
Right, sure. So, like I mentioned, in trademarks, I spoke about due diligence, right? So, which means to say that I said you need to look for other trademarks that might be similar in your field of business. In patents, due diligence is an extremely crucial step. So
Hmm.
one would do what is called as a prior art search or a novelty search or a patentability study. So essentially,
Hmm.
whatever the name might be, essentially what one is trying to do is look for patents spread across the world, or literature, non scientific literature, so on and so forth, to see if there is anything that exists in public domain that might be similar to what I'm trying to protect, right? And based on what we find, try and assess what is the chance that we will get a patent granted, given the difference between what we have come up with and what already exists. Is the difference sufficient for me to get a patent granted? Right? So ideally, if you are a startup and crunch for funds, you would go for something like a site like Google Patents, which has a database of patents from a bunch of countries, easy interface to search, so on and so forth. You would ideally do your own due diligence to look for other documents, other patent documents, and see if there is something similar. And if you are looking at if you're, let's say, filing patent applications in multiple countries, or after you have done your initial research, you would engage with somebody who actually knows how to do a patent search. And somebody like me would do a patent search using certain paid databases covering patent data from hundreds of jurisdictions. And these searches are not like your normal Google searches. These are complex queries that are run to identify patent documents that might be similar to what we are trying to protect, and get an opinion as to whether the chances are good or not. So a budgeting for something like this could be as low as 10,000 bucks to something as decent as about 35 to 40,000 rupees for a due diligence like that. And a due diligence like that, and why that cost varies, there are multiple factors. One could do a due diligence in just one day, doing very quick searches, whereas it could be fairly comprehensive, wherein somebody would charge more. But getting a due diligence done at whatever comprehensiveness that you are comfortable with is I would say is a must. Because once the process of applying for a patent and getting a patent granted, one is time consuming and also could be quite expensive, right? So you would want to get do your homework before you decide on applying for a patent. Now once you have done your due diligence and you want to say that, okay, I want to go ahead and apply for a patent, you could go ahead and file what is called as a provisional application. And in case you were to start off your filing as a provisional application, then within 12 months you'll have to file what is called as a complete application. On the other hand, you could start off your application as a complete application itself, right? And you would take this decision whether I want to file a provisional plus first and then a complete, or a complete application straight away. It's a bunch of things based on which you will take this call. Now, let's say you have eventually filed the complete application as a first application or as a subsequent application. It is the complete application that will be examined by the patent office. Now, the patent office also will do the similar kind of due diligence to look for patents or some literature which might be similar to what we are trying to protect. Now, based on this due diligence, the patent office might come back and say that I'm going to grant you a patent, or they might say that, okay, well, I have a set of objections, and I have found certain, set of patent documents and references and publications, and in view of these things, we feel that we cannot grant you a patent, right? So two scenarios: one, they examine it and they are convinced; second is they are not convinced, they are issuing this examination report with a set of objections. Now, from a practical standpoint, the patent office, at least the Indian patent office, will almost always, I would say 100%, will come back with an examination report. So you need to be ready with this. So an examination report will typically have a bunch of references, and in view of these references, the patent office will be objecting, saying that, okay, well, we think that's very similar and we cannot grant your patent. So which we have to now respond by differentiating those documents from what we are trying to protect, tweak a certain aspects of what we are doing in terms of there is something called as claims. We would have sought a broader form of protection. We slightly narrow it down and saying that, okay, well, I will now narrow my scope of protection, and then try to convince the patent office in by way of written communication. Now, if the patent office is convinced, they'll say that, okay, well, we will go ahead and grant it. If they're not convinced, again, a one-on-one video conference like this, where we try to convince. And eventually a decision is taken whether a patent should be granted or not, right? So this is like the process involved. Now, in terms of expenses, if you're talking about startups and mid-sized companies, so on and so forth, there is a huge discount on the patent office fees, and then they can go for what is called as an expedited process. And well, they would spend about 12,000 rupees odd in government fees, right? That would expedite, for example, a normal process. If it were to take about 3.5 to 4 years, in an expedited process, you would pretty much wrap up everything in about a year's time, and for not much of government fees involved, which is roughly about 12,000. So while that is the government fees, much of the expenses that one would incur is actually in terms of the professional fees, right? So, for example, I mentioned about the due diligence, which could range from, let's say, about 15,000 rupees to about 35, 40,000 rupees. Now, when it comes to a complete specification drafting and filing, now that range, depending on who is working on it, their expertise, so on and so forth, it could range from about, let's say, 50,000 rupees to a lakh, right? And then eventually, when it comes to arguing with the patent office, now you are looking at an expense ranging from about 25,000 rupees to about 40,000 rupees in that particular range, right? So you're looking at roughly about, I would say, including the government fees and all of that, roughly between, I would say, 1 lakh, 1.2 lakhs to about 1.5 to about 2 lakhs. So we are looking at that kind of a range in terms of an Indian patent, the whole process. And in terms of timeline, we are looking at 12 to, I would to be on the safer side, I would say about 12 to 18 months is the timeline that you're looking at to kind of wrap up this entire process.
Okay. So, taking a short break in our discussion, there is an interesting question here that Gaurav is asking. Is saying, if a company has more than one brand names, so should they take patents and trademarks individually on on like each name, or like how does that happen?
Yeah. So, we are talking about, so I think what he's referring to is a trademark. So the brand name is
Hmm.
protected as a trademark. So if a company
Right.
has multiple brand names, then they would, yes, apply for trademark application for each and every brand name. Not just that, so for example, let's say if I were to look at, let's take the example of LawSikho itself, right? Now, LawSikho probably has, let's say, a logo, which could be a stylized way of writing LawSikho, as an example. And then there is a word itself, LawSikho, right? So ideally, I would go ahead and get at least the word registered, right? So that's the base. I want to get the word registered, because if I get the word registered, that's like the broadest form of protection. If I get the word registered, I can stop others from using that word in whichever stylized way, right? As long as they're in the similar field of business. So, as a base, I would get the word registered. But over and above that, if I have that flexibility, I would also go ahead and apply for another trademark, which now protects the stylized way of protecting that particular thing. So, for example, if I am
Okay.
talking about YouTube, I will protect the word YouTube as one trademark application. That's the base, must do. But if I have the flexibility, I'll also go ahead and protect the whole YouTube logo as well, right? So to answer your question, yes, ideally, there would be multiple trademark application covering different aspects of the trademark, like the word and the logo separately. But the priority would be start with the word because that gives you the broadest protection, and then move on to the next aspects if at all that flexibility is there.
All right. And say, what if in the case like if a company has a lot of sister concerns? Let's take an example of a company or a startup that has some sister concerns, and like
Right.
all the sister concerns have different names, right?
Yes.
If we can take an example of some tech giant, for example, Tech Mahindra or Tata, you said. So they have sister concerns that have a little bit different names, right?
Yes.
Little bit, they are changing their names. So in that case, if there is a brand name that has brand name or a logo or a patent for that matter has to be registered. So how does that happen? Like, will that patent or mark be registered in the name of the main concern or in the name of every concern?
No, no, no. So ideally, you would just register. Now, one is who is going to be the proprietor of this particular trademark is the question. Who is going to be the owner of this
Right.
trademark? Who is going to be the
Hmm.
applicant of this particular trademark? Right. So the
Hmm.
applicant of this trademark could be the sister concern itself.
Hmm.
Not necessary that it has to be from the parent company, right?
Hmm.
So for example, let's say under Tata there is Tata Motors,
Right.
right? There is Tata Consultancy, right? There could be so many different companies that probably fall under the broad umbrella of Tata Group,
Hmm.
right? Now, under Tata Motors, there is, let's say, an Indica car,
Hmm.
right? So that's a trademark. Now, ideally, I mean, that's what would happen. Tata Motors, which is an entity by itself, a legal entity by itself, is the one actually who is going to be using that particular trademark, right? So
Right.
it is Tata Motors who will go and apply for trademark for on the brand name Indica. So likewise, Tata Consultancy, which is now another entity, would probably, let's say, comes up with another some kind of a software, and there is product software product and it has a name. It is Tata Consultancy Services Private Limited, which will go ahead and apply for trademark for that particular product, right? So to answer your question, it is the company that is going to be using that particular brand name that is ideally going to be applying for a trademark. And then there could be trademark agreements between the parent company and the sister concern, so on and so forth. So that's a completely different thing. But typically, the actual entity which is going to be using that trademark, which is typically going to go and apply for that trademark registration.
All right. Okay, sir. Thank you for that answer.
Sure.
So, coming back to our topic, we were talking about patents. So, the next thing that I wanted to ask about patents was the international process of it. Like, if
Okay.
someone wants to register it internationally, how does that go?
Right. So yeah. So that's a very common thing companies do, and we kind of explore and we kind of do it very frequently. So one is, when it comes to filing trademark applications in foreign countries, one of the key questions people have is that, okay, how do I actually pick that country? In which country should I
Hmm.
file? Right. So the
Hmm.
answer to that is one. You kind of ask yourself, am I going to be doing some kind of business in that particular country? That's one. If
Hmm.
actively there are customers in that particular country, and then I'm going to be actually doing a business in that particular country, I would want to have that monopolistic rights on that particular technology in that country. So I would want to file it in that country. That is how you pick. Now the second order of judgment is that, okay, I may not really be doing a business in that particular country, but is this technology relevant in that particular country? Will this technology have some value in that particular country? Right? Some technologies might be very I would say, geography specific. Some technologies might be very specific to India, right? It may not really have that global kind of a reach. But whereas there could be certain technologies that might be relevant in some few other countries. So that is how you would say that, okay, I might even consider all of these countries. So that is a process of kind of figuring out, in which countries that I would want to file. right? So that's one level in terms of thinking. Now the second thing is about actually going ahead and filing patent applications in different countries, right? So there are multiple approaches that one could take. One is, there is something called as uh, India and a bunch of countries are part of what is called as Paris Convention. So, which means to say that all of these countries have kind of come together and said that, okay, if you were to, if somebody were to file a patent application, let's say in India, which is a member country, then within 12 months, you can file the patent application in another foreign country. So, for example, US. And that US application filed within 12 months will be treated as if it was filed on the same date as the Indian application. You get a
Hmm.
priority date for that US application as long as you are doing it within 12 months, right? So once you
Okay.
have filed that US application, just like how I explained with respect to India, the US patent office will do their own examination, and then there will be their scrutiny. One will have to engage with an attorney there, respond, so on and so forth. So we actually end up doing a lot of these US filings, and we end up helping companies with the prosecution filing and the grants and all of that, right? So likewise, in different jurisdiction, you will go ahead and file these individual applications in all of these different jurisdiction, and each patent office in that particular country will scrutinize your application, and then there's this whole process of to and fro of arguing, and eventually a grant or no grant. So that is one process wherein you have to take a call within 12 months and file applications
Hmm.
in all of these different countries. The other way of doing this is what is called as an international patent application. So one should not confuse the name international patent application to mean that if I file an international patent application, I will get an international patent which is applicable everywhere. It is not that. So international application is a stopgap arrangement. So, for example, if I were to file an Indian application, within 12 months of this Indian application, I can file an international application. Now, if I file this international application, what it does is that it will give me about 2.5 years, about 30 months from my Indian application filing date to decide and file in all of these different countries, right? Bunch of countries that are there. So essentially, by filing this international application within 12 months of my initial Indian application or whichever first patent application, I am essentially buying myself time for about 2.5 years from my initial filing date to decide which countries to file and file it within those 2.5 years. So the advantage of doing
Okay.
something like this, as compared to the previous one that I spoke about, is that in the previous approach you had to file it within 12 months. So if you have a bunch of countries, you are making all of those expenses within a very very short period of time, right?
Hmm.
Whereas in this second approach, you are buying yourself about 2.5 years to decide and file. So typically in those 2.5 years, you will have a far better idea as to whether this technology is going to be successful or not, right? From a financial standpoint, you will be in a much better position to decide, whether I can afford it or not. Or in those 2.5 years, you can figure out in some of these countries, are there other people who might be interested in my patent application, and do
Hmm.
some kind of an arrangement with these other entities who might be interested in some other jurisdiction where you may not be really interested in. So you're buying yourself more time through this international application. So essentially, my suggestion is that if you're not very sure which countries to file it in, and if you are want to buy yourself more time, an international application is a great strategy. I mean, we use this strategy for a lot of startups, right? And even large companies who file it in a lot of jurisdictions, right, they go for international application route. At the same time, there is a possibility that you can actually use both of these things, which means I file an Indian application within 12 months. I'm very sure that US is a very sure sharp market. I will file this 12 within 12 months US application. At the same time, I will also file this international application, which now gives me opportunity of that 30 months time for all the remaining countries to decide. So you can mix
Hmm.
match this strategy and then kind of decide how you want to go about in terms of international filing of patent applications.
Okay. And on which stages, like in the trademark as well as in the patent, on which stages, at which stages are attorneys required? Because
Yeah, I
you have
mean,
discussed the processes, but the startup founders may be confused, maybe getting confused that where should we get the attorneys involved.
right. So pretty much when you talk about patents, right from the due diligence, you are, you know, involving an attorney. So I
Okay.
mean, there is no way one would be able to navigate this process without
Hmm.
somebody who has like deep expertise in patents. And patent is a field which requires, deep expertise. And once you apply for a patent, you cannot change, except for one little part which is called the claims. Rest of the patent document you cannot make any more changes. So and the technology is too valuable to some for somebody to say that, okay, I will just do some research and then go ahead and apply for a patent. That doesn't happen. I mean, anything can be done all by yourself, right? One needs to kind of decide how valuable something is and what the outcome needs to be. So as a professional, my sure short answer is that, you need to be engaging with an attorney to be able to do this. At least the trademark process, at least the filing part of it, if one were to, like, sit down and do all of the research, you'll be able to file it, at least. But when it comes to examination, you will definitely require somebody who has expertise. But when it comes to patents, there is absolutely no way, in my view, for somebody to kind of navigate this whole process without an attorney.
All right, sir. Thank you for that answer. So Gaurav has one more question. He's asking, I'm starting a brand very soon. Now, as it is my brand's initial or starting period to be start, but if someone's stolen my idea, so what should I do? So he's basically asking that what if some before he registers, what if someone steals his brand identity? That's
So
what I
yeah,
took from his question.
right. See, you have not started your brand, right? So I might say that, okay, I have a brand name called as Go Local, made up name, Go Local, and I am going to be selling, let's say, juice under that particular brand name. I have something like that in my mind. Now somebody else, actually starts this particular brand, Go Local, and is starting, he or she is selling, let's say, something like juice. I cannot really do anything about it, right? That person actually, did not necessarily steal it from me, but that person,
Hmm.
did something by themselves and then went ahead and did it. I can do nothing about it. But if actually somebody, let's say, I'm talking to, let's say, an investor, and now this investor goes ahead and, steals that particular brand name and start something by themselves using the same brand name. Yes, in that particular scenario, you can, get that brand name invalidated, so on and so forth. So all that can happen. The other part of that question was something to do with idea, whether somebody can steal an idea and what to do about that. See, ideas cannot be protected in whichever form. Ideas are just not protectable. So these are the different things that can be protected. Brand name can be protected, technology can be protected, aesthetics of a product can be protected, some trade secret can be protected. But let's say I have an idea to say that, okay, I will aggregate, let's say, people who do, handcraft, right? And I will sell it on my e-commerce platform. So that's an idea, right? So let's say, some I come up with this whole business, and then I've started this particular business, and somebody sees that, okay, this looks like an interesting idea, and starts a business with the exact same idea. Now, nothing can be done about it. They are free to go ahead and copy business models. Business models are not protectable. Ideas are not protectable. It has to be within these broad things which are protectable. Anything outside of that, such as an idea or a business idea, cannot be protected.
Okay, so as long as Gaurav hasn't started with his business, he cannot protect it
Protect the brand
essentially.
name, yeah. Brand name is
He
not
cannot
protected.
protect the brand name, of course.
Yeah. I mean,
All right.
even before you start, if you want to protect, go ahead and apply for a trademark registration.
Hmm.
That is some way of protection.
That's
But without
right.
even
That's something
registering,
very
without
true.
even registering, without even using, I mean, protection is just impossible.
Right, right. So just to add something to it, Gaurav, there are two kinds of applications that can be filed. Like you have been already using your mark and a mark that you will use, intended to be used, in future. So you can like as Karthik sir said, you can file an application even if you're not using the mark right now. You can still go ahead and file an application so that you have a date to your brand. You get a date to your brands, and if after that particular date, like you have filed an application and someone tries to steal it afterwards, you will have something to show. Like that's what my input would
Yeah,
be
so you
to it.
can file it as what is called as proposed to be used. So that's the
Hmm.
scenario wherein you have still not started using it, but you propose to be used. So you can go ahead and apply for a trademark registration saying that I propose to use it. The other
Hmm.
way is you have already started using it, in which case one we would file what is called as a user affidavit showing when
User
it
affidavit.
started, when it was started first using it, and a bunch of things associated with how extensively we have used it, so on and so forth in the trademark application.
Right. So I hope, Gaurav, that answers your question. And since you are starting a brand, I guess this session was like it would be beneficial to you. So that was all from my end. And in conclusion, I would like to extend my heartfelt gratitude to you because you took your time out from a busy schedule and gave all these insights with respect to IB to all of us. And I am like really grateful that I was the one who got to host this webinar with you.
Yeah.
And thank you so much. And thank you
And,
everyone
and,
for joining us today.
and it
Hmm,
was
please.
excellent interacting with you, Manita, and very pertinent questions. And I kind of got to share insights which otherwise, would be shared in bits and pieces in smaller groups. So this was wonderful. Yeah, thanks for having me on this podcast.
Thank you. Thank you so much, sir. Thank you for being here.
Yeah,
Have a great night.
you too. Good night.
Thank
Bye.
you. Thank you all. Bye bye.
Bye.